screen back here. It's live. Hello, Matt.
Like he's not, he's just in the audience. Right.
microphone to do your opening?
No, I'm just going to go up to the podium. Thank you.
Sure. Trying to keep things moving.
Setup, do you think the judges are going to do like wrestling intros, the walkout music?
Oh yeah, did you know them to walk that song? They asked me if I knew. I said they should do the chicken dance for you.
Oh yeah. Well, you know, just don't take any offense when I do the mad dog during the pre-fight talk. It's all in good fun.
All rise. This Court of Appeals of the 11th District is now open with the Honorable Judges Matt Lynch, Robert J. Patton, and Scott Lynch. The Honorable Judge Matt Lynch presiding. All having business with the court draw nigh, and they will be heard. God save this honorable court, and you may be seated.
Okay, is that better? Good morning, Berkshire. Thank you for hosting us. Let me just remind everyone that this is a real case involving real people with real consequences, and so we want to treat this matter with the seriousness with which it deserves. And so I will call our case today, which is 2025A0038, State of Ohio versus David M. Forgas. Counsel for the parties ready?
Yes, Your Honor.
Yes, Your Honor.
All right. Now, when we're at home, in other locations, we give the attorneys each 15 minutes to argue, but when we're at the high schools, we give 20 minutes. So, counsel for appellant,
Thank you, Your Honor.
if you would announce yourself for the record, we do record all these proceedings, so you'll have a total of 20 minutes. And how much would you like to reserve for rebuttal?
5 minutes, please, Your Honor.
Very well, you'll have 15 minutes to begin, and you may begin when ready.
Counsel, you may want to lift the microphone up a little bit so they can hear you. Yes. Or you could just hold it too.
Yeah, all right. How's that?
Yes.
Great. Okay. May it please the court, I'm Adam Parker, counsel for appellant David Forgas. So in this case, Mr. Forgas was indicted in the Ashtabula County Court of Common Pleas on a single count of aggravated trafficking in drugs. That charge was elevated from a second to a first-degree felony based on inclusion of the additional finding in the indictment that the offense took place within 1,000 feet of a school. Mr. Forgas pled not guilty and proceeded to a jury trial where he asserted the affirmative defense of duress. After deliberating, the jury found him guilty of both the substantive trafficking count and the accompanying additional finding, and the court imposed a sentence of a minimum of 6 and maximum of 9 years. I'd primarily like to use my time here today to talk about the statutory definition of a school and how that affects the court's review for sufficiency and manifest weight of the evidence under the second and third assignments of error. The jury in this case convicted Mr. Forgas of the school's own finding were the only relevant evidence at trial that the place they were talking about met the statutory definition of a school was testimony that the name of this place was the YMCA Early Learning Center. And I do acknowledge that the Supreme Court held in State v. Manley, it did uphold the school's own finding based on testimony about the school's name, and several other Ohio courts of appeals have also done that. But none of those decisions squarely address the issue that we've presented to the court here, which is that a preschool, nursery school, or daycare is not covered by the statutory definition of a school. And for that reason, Manley and those other decisions are not controlling of the outcome in this case. The statutory definition of a school that applies here is found in Revised Code section 2925.01 subsection Q, and that definition contains 3 categories of schools. The first is a school that's operated by a board of education, which more or less means a public school. The second category is community schools. Notably, a community school is a kind of public school that's run by the state. Its distinguishing characteristic is just that it exists independently of any school district. Then finally, the third category is a non-public school, which is subject to the minimum standards set by the Director of Education. So in order to convict Mr. Forgas of the school's own finding, the state had to present proof beyond a reasonable doubt that the YMCA Early Learning Center matched one of those 3 categories of schools. And while we don't dispute that that can be by circumstantial rather than by direct evidence, still, whatever evidence they present at least needs to support an inference that would allow a rational juror to conclude beyond a reasonable doubt that it matches that statutory definition.
And what was the evidence that was presented?
So there were 2 things, Your Honor. First, there's the testimony of Detective Gale, which was essentially just this constitutes a school. And that's not really direct or circumstantial evidence. That's a conclusory legal opinion. That doesn't carry evidentiary weight.
Was there any objection made to that testimony?
Well, no. The issue isn't whether it should have been admitted, although I guess in theory defense counsel could have argued that. But even having been admitted, it simply doesn't have any evidentiary value. The court shouldn't consider it in doing sufficiency or manifest weight review. It wouldn't be meaningfully different than if we're in a murder trial. The prosecutor calls the detective to the stand, something like, "Detective, did the defendant's conduct constitute murder?" Why, yes, it did. Okay, the state rests. Right, there'd be no dispute there that that's not sufficient evidence to sustain a murder conviction. It's the same thing here, regardless of maybe whether it should have been admitted or not. So then the second bit of evidence going to the existence of a school is testimony about the name of the school, which again was the YMCA Early Learning Center. And that does carry a bit more weight. I say that because Manley and several other decisions from the courts of appeals have upheld the school's own finding based on testimony about the name of the school, saying essentially that, a jury could infer from the name that it's a school.
Counsel, is that the whole name? Importantly, I understood the name to be YMCA Early Learning Center Daycare. Can you clarify that for me?
I believe that is the full name. But it was, I think, primarily referred to as the YMCA Early Learning Center. And I think, I mean, for reasons that we're going to get into, if there's any discrepancy, I don't think it should affect the outcome. So while Manly did uphold the school's own finding based on the name of the school, it's important that the court not read Manly too broadly and keep in mind what issue was actually presented there. What Manly was deciding, the issue was confronted with that had been raised by the parties, was whether the state, in order to prove that this school was operated by the school board, did they need to have some employee of the school board come and testify to that fact? Or instead, is that something that they could prove by circumstantial evidence? And the court holds the latter. It can be circumstantial. That's the holding of Manly. Manly shouldn't be taken for the proposition that the name of the school in all circumstances and in every case is going to be sufficient. That would be an unreasonably broad reading of that decision, and it's not what the court said.
Counsel, do you recall the name of the school in Manly?
I believe it was the Whittier School, Your Honor.
And should we be taking those facts differently in that we don't have actually the name school in the name of the case at bar?
I don't know if the word school is the dispositive fact, but I do think the particular name matters, right? Like I'm saying about Manly, it doesn't stand for some sort of default rule that a name is always sufficient evidence. Instead, like it does with any other case, the court has to consider the sufficiency and manifest weight of the evidence in light of the particular unique facts of this case, which includes, yes, Your Honor, what the name is. The question is, if the only evidence we have to go on is the name, then would that name support an inference that would allow a rational jury to conclude that this has been proven beyond a reasonable doubt?
Counsel, can you give me more on that? Because it's, as you know, it's difficult for this court, it's impossible for this court to overturn Supreme Court precedent. So if we're not making, so is your contention that it's only a factual distinction with Manly or something else?
It's partially a factual distinction and also partially a issue of party presentation of issues. I think that Manly addressed a particular issue. Again, the Court of Appeals decision that Manly was reviewing was that essentially there wasn't sufficient evidence because nobody had testified from the school board to establish the fact that a school board operated this school. So I think the Manly holding has to be viewed in light of what issue was presented by the parties, what the decision below it was reviewing was. And I think Manly doesn't control this case for that reason. There's a specific issue that we presented here that neither Manly nor any of the other cases addressing the name of the school had occasion to address, which is, that's something that's a preschool or daycare isn't covered by the statutory definition. So again, the three categories that we have to work with here for schools is 1, operated by a Board of Education, 2, a community school, which I'll mention again is still a kind of public school if we look at Revised Code 3314.01, and 3, non-public school, subject to the Director of Education standards. So
isn't this issue being reviewed on plain error?
No, Your Honor, because it's sufficiency of the evidence. I know there is some language in Manly to the effect that defense counsel had some affirmative obligation to preserve this issue. What I can say to that is we do have a Rule 29 motion to dismiss in this case that did specifically challenge whether there is a sufficiency, whether there was sufficient evidence to sustain the school's own finding. That should be sufficient to preserve the issue for appeal. I think if we read Manly to require more from the defense than that, then Manly no longer makes sense in terms of the burden of proof. I don't think we can take Manly to mean that there's some affirmative obligation to present evidence that this is not a school or make a more specific argument than a Rule 29 motion challenging the finding. So if we turn back to those 3 categories of schools, again, the question is something that's a daycare or a preschool covered within those categories? And is something with the name YMCA Early Learning Center Daycare covered? It should be obvious that the first 2 categories are out right off the bat. It's common knowledge, it's generally known that the YMCA is a private, non-profit organization. It's not part of the government. That's something that anyone would know. So no rational juror is going to hear the name YMCA Early Learning Center or daycare and think that that might be a public school of some kind or another, and therefore they wouldn't conclude that that's a match for either of those first two categories.
Well, here's the difficulty with that. I grant you that might be a matter of common knowledge, but there was no discussion or evidence in the record about that issue. I suppose it's conceivable that you could have some public school activity at a YMCA. I don't know, but if defense brings nothing forward, Manley was based in part on the name of the school, but was also based upon the testimony of the officers involved, right? Very similar to what we have here. We have a name of a learning center, a school, and the officers testify that was a school for purposes of violation of the statute. So how does that get distinguished from Manley?
Well, I don't know that we can necessarily make the leap saying that learning center implies a school. I think
Well, that was the testimony.
The testimony was that constitutes it as a school.
Yes.
Again, I don't think that carries any evidentiary weight. I think that's essentially a conclusory legal opinion. Conceivably, an officer could testify, as sort of lay opinion testimony. I am familiar with this school. I know maybe what grades are instructed there, or I know that it's a public rather than a private school. But we don't have anything like that. We just have that constitutes a school. And we don't have any testimony. Even if this were something that were relevant, even if we're allowing that an officer would be somehow qualified to testify about the legal definition, we don't have testimony specifically as to that, rather than just saying that it's a school in a more sort of generic everyday sense of the word. And a conviction for the school zone finding does require evidence that it's a school as defined, not in a merely everyday sense. The only category that isn't ruled out based on it being a private versus a public school would be category 3, non-public schools, which so far sounds like you could be in business, but then it still has to be subject to the Director of Education standards.
Well, in Manley, was there testimony about the school, the Whittier School, being part of or under the jurisdiction of the Board of Education?
No, and I don't think that that's necessarily required. I think when it has the word school in the name, then maybe it is possible to read that inference. If we're talking about light and most favorable to the state under sufficiency of the evidence review, then maybe it's possible to read that in favor of the state, that could be, a jury. If there's no other evidence for them to consider, they could infer that that is a grade school, which would fit one way or another into one of those 3 categories. The name YMCA Early Learning Center simply doesn't support the same inference because it suggests a preschool, a daycare. So we do have to ask the question, well, what schools are subject to the standards the director sets, which the enabling statute for those standards is Revised Code 3301.07. That's the statute that gives the director authority to set minimum standards. And if you read that statute in its entirety, it does limit that rulemaking authority to kindergarten. It says elementary and secondary schools. In other words, kindergarten through 12th grade. You'll notably find elsewhere in the same chapter of the revised code that standard setting authority for preschools or daycares is delegated to a different department. If you look at the minimum standards themselves, they confirm the same thing. Those are in the administrative code, chapter 3301, and section 39, rule 1 of that chapter also says that the rules only apply to schools for compulsory school-age children, again, K through 12. So if we're considering that, even in the light and most favorable to the state, a rational jury couldn't hear the name YMCA Early Learning Center daycare and infer that that might be a K through 12 school. Therefore, they couldn't conclude that it would be within that 3rd category. And there's no other basis for concluding that this would be any of the 3 categories of schools that the school zone finding applies to. I do have to discuss the other decisions that the state cites to, because there are several courts of appeals that admittedly have held that there was sufficient evidence to uphold the finding based on testimony about the name of the school. So Howard and Mielke are the easiest ones to address. In both of those cases, the name of the school in question did have kindergarten in it. And that's a pretty obvious and important distinction from what I've been just talking about with daycares or preschools, right? Because it might be reasonable for a jury to infer that a school with kindergarten is in the name is a K through 12 school. Specifically, it might be a kindergarten. So those are factually distinguishable. Curiale is a little bit more difficult because admittedly it had a similar name involved there, which I believe was Faith Presbyterian Head Start. That's similar because that also does suggest a preschool or daycare rather than a grade school. But again, this comes back to the issue of party presentation. The specific issue that I'm arguing here, whether a preschool meets the definition, doesn't appear to have been raised by the parties in Curiale. So the court didn't have occasion to consider it. If I can conclude briefly, Your Honors.
Finish your
Okay.
thought.
So as I'm arguing in my first assignment of error, which I haven't discussed on the record here today, but we are asking that the court reverse and remand for a new trial, or in the alternative, based on the insufficiency or manifest weight of the evidence as to the school's own finding, that it should modify the conviction from a first to a second degree felony and remand for resentencing. Thank you, Your Honors.
Very well, thank you. We'll have you back for 5 minutes. Belly, thank you once again. If you announce yourself for the record, and you have 20 minutes, you begin when ready.
Thank you, Your Honors. Attorney Dane Hickson, bar number 0103833 for appellee, the Ashtabula County Prosecutor's Office and the State of Ohio. May it please the court, counsel, students, and teachers. I want to start today with actually the first assignment of error, because we're here to discuss what the duress defense is and what it is not. The duress defense is a very limited defense for cases in which the defendant is compelled to commit a crime under a threat of immediate, imminent death or bodily injury. This threat also needs to be consistent throughout the entire length of the act. These requirements are very firm because of the unique nature of a duress defense. The most common affirmative defenses we deal with are self-defense and defense of others, as I'm sure this court is aware. Those cases deal with harm coming to a guilty party. The party who is injured by the actions of the defendant is someone who was provoking that action by some other threat of violence. In a duress defense, the person coming to harm, the victim of the defendant's actions, is an uninvolved, innocent third party. That's a critical distinction, and that's part of why duress defenses are so rare. Now, the duress defense is a very limited one, as I've mentioned. As noted by this court in the State v. Strickland decision, the defense is extremely limited and should only be applied in rare instances. Under State v. White, a fear of future harm cannot be the basis of a duress defense. The harm must be in presente or happening in the present moment. Finally, the person raising the duress defense must be without fault in bringing about the situation pursuant to State v. Nelson. On this first assignment of error, I disagree somewhat with counsel as to the appropriate standard of review. I know that they cited de novo as the appropriate standard of review. I believe abuse of discretion is proper because this is an evidentiary question which raises mixed issues of law and fact. Therefore, abuse of discretion is proper. Abuse of discretion requires some deference to the lower court's decision. De novo, of course, as this court is aware, would allow basically a review from the start, ignoring the decision of the lower court. Now, for the first assignment of error, we have this relevance issue. For evidence to be relevant, it needs to meet a very low bar. It needs to make a material fact more or less likely for the proceeding. But the proposed testimony at issue does not even meet this incredibly low bar, Your Honors. It's offered to prove one fact and one fact only, that appellant was scared of Mr. Clark. But Mr. Clark was not there for much of the transaction, Your Honors. It doesn't matter if I'm terrified of Judge Patton, for example, if Judge Patton isn't there when I'm committing a criminal act. That doesn't give me a duress defense. It just means that I'm scared of someone, and that ceases to be a material fact.
Okay.
Counsel, what do you do with, hypothetically, a long-term pattern of abuse, or at least I think some of the evidence in issue that was kept out is a prior history of violence. What do you do with that, with the immediacy element?
Well, Your Honor, I think that can be relevant if that figure is there for the entire duration of the crime. This would be a very different case, and I would have to make a very different argument if from the get-go, Mr. Clark's in the back of the car and maybe potentially armed. I think that's a very different case. But what we have here is he arrives halfway through this deal based on appellant calling him. That's not a duress defense at that point, Your Honor. It's closer to Strickland, where maybe there's this person who's threatening, but they're not there for the entire crime. The duress defense still failed in Strickland, and there it was someone who allegedly had him at gunpoint standing outside of a gas station, and this court said, as soon as you entered the gas station, the gun wasn't on you, you should have called the police. Here we have the same circumstance where at the start of the transaction, Mr. Clark is nowhere around. There's nothing that forced appellant to get in that car. So it's not relevant how scared he is of Mr. Clark if Mr. Clark isn't there to create that imminent fear. Does that make sense, Your Honor? Thank you.
Well, I'm not sure it makes sense to me because
Okay.
You're suggesting that because he wasn't there at the beginning of the transaction. So Fergus is at his home and he actually displays the drugs, and
Yes.
and Mr. Clark, who later attacked him, at least there's testimony that he later attacked him,
Allegedly. Yes.
allegedly, that he wasn't there at the beginning. But when was the crime committed? Was it at the house at that earlier time, or was it later when the drugs changed hands?
Well, I think there's still a crime committed at that earlier time. There's at least the attempt at that earlier time. The transaction, I will grant you, is completed, but it needs to be imminent throughout the entire duration of that criminal act. The criminal act includes that part at the beginning. And so
you want us to see the transaction as a whole,
yes.
but you want to exclude the Mr. Clark, who allegedly pistol whipped Mr. Fergus, exclude that as not being as part of the whole.
Well, it can be part of the whole, Your Honor, but
I mean, when Mr. Fergus does get the drugs from Mr. Clark, and he testifies, I don't want to take these drugs out and complete the transaction, he says Fergus pistol whipped him.
I understand that, Your Honor.
So that sounds like quite a bit of duress.
But, Your Honor, it has to be for the whole act. The problem here is, Your Honor, this whole act needs to be considered. And so for a duress defense, the threat needs to be present throughout the entirety of this criminal act. So at the start, which I agree should be considered to be part of this whole
let me
act.
interrupt you. If Mr. Fergus had refused to take the drugs out and walked out his front door and down the street and left it, we wouldn't be here.
I agree, Your Honor.
All right. So
But if
the
Mr.
crime
Clark-
was related to the transfer of the drugs, the delivery of the drugs, if you will.
Yes, Your Honor, but if Mr. Fergus hadn't been in the car before Mr. Clark got there, we also wouldn't be here. So
Fair enough.
that's where I'm at, Your Honor.
Counsel, that somewhat strikes me more as a harmless error argument rather than whether the evidence was properly excluded.
I think it's both, Your Honor. It can be a harmless error argument, and I do in fact make that argument. But it's also a relevance issue because if Mr. Clark is not present, then the threat cannot be imminent throughout the duration of the entire transaction. And thus, any fear is not relevant to a duress defense because it does not make the requirement of an imminent and immediate fear for the entire transaction more or less likely.
But there are certainly self-defense cases where we look at state of mind.
Yes, Your Honor.
And you don't think that has relevance here?
I truly do not, Your Honor. As I've described earlier, self-defense is simply a different defense than duress. Duress has different harm to different people and should be considered differently, in my mind. So then I also just want to briefly note on this issue that appellant is, I think an even stronger point on this matter is that appellant is at fault for creating this situation, any way you slice it. He called Jermaine Clark. He went to Jermaine Clark to get these drugs. He is at fault for creating this situation. And even his fear of Jermaine Clark is based on him owing Mr. Clark money for drugs. That is him creating this situation, and therefore it is ineligible for a duress defense from the get-go. Now, my opponent has focused a lot on the school issue, so I'd like to move to that now, unless there are any further questions on the duress argument. Appellant takes issue quite strenuously, it would seem, with whether we have sufficiently proved the offense happened within the vicinity of the school. It's worth noting the bar here isn't a high one. Manley does hold that testimony about the name of a school and it being a school is sufficient, and that's exactly what we have here. We have the YMCA Early Learning Center daycare and testimony that it is in fact a school. Plenty of cases support that we've done our jobs here, Your Honor. In Howard, a witness's approximation of distance was sufficient. Same with Curiel. The distance doesn't seem to be much of the issue anymore, but it's worth noting that an approximation of distance, even without Google Earth, is sufficient. However, for this specific school zone specification, I would just like to read, because I did make a list of the cases and what the names of their schools were with similar testimony that they're either a school or a kindergarten/daycare. In Curiel, it was Faith Presbyterian Head Start Daycare. In Taylor, it was Highland Head Start. And in Mielke, it was Kindergarten. Your Honors, all of these are very much less obviously a school than the YMCA Early Learning Center daycare. Kindergarten, to me, sounds like it might be a competitor to Lowe's. So, appellant cites the two cases on this point, Darling and Shaw. I'm willing to concede that Shaw presents a different way of looking at this issue, but it's not one that's been accepted by other districts or the Supreme Court. And in Darling, the state admitted that it was wrong. They conceded the error for reasons that I frankly don't understand. I believe that they would have won had they actually contested it, but they conceded it. And so that case is different from the present matter because I very much do not concede this issue. In conclusion, Your Honors, we did our job in this case and we did it well. Appellant never had a duress defense as a matter of law, and we followed exactly what the Supreme Court said we had to do in Manley.
Counsel, I'm going to ask you to focus in on this name issue.
Yes, Your Honor.
Quite a bit, if you would.
Very good.
It's not obvious to me that something called a learning center daycare is a school on its face.
I understand that, Your Honor.
And I think one of the things that we have here, you know, there's lots of cases where what lawyers do is we argue over the meaning of words,
yes,
right? But from a textualist approach, we don't really have to figure out how many angels are dancing on the head of a pin when it comes to school here, because there's a very, very specific statutory definition of school here. And yes, I understand your points about Manley, and I'm happy to hear that here again. But in Manley, we have something called a school.
I do understand that, Your Honor.
Here we have something called a learning center daycare. So it's not obvious to me that the learning center portion, and I know we have Head Start cases where you're citing to that also says it's a school. But to me, the learning center part seems stronger that it is perhaps a school. But once you have the word daycare, I don't know if that's just marketing. This might be a daycare where they're really good at, making sure the kids learn their ABCs or have an educational approach to the care that they're having.
Yeah.
So we're limited to the record.
I understand that, Your Honor.
And do more for me on that point, because it's not obvious to me.
Well, Your Honor, again, I would point to two things. We do have something else on the record. We do have the detective's testimony that this is a school.
Well,
I do make that an important point, Your Honor.
Well, he used the words constitutes.
It constitutes a school.
For me, and I know our sheriff is here. I don't know if he'll appreciate the joke, but I have a cousin who's a detective, and I always joke that lawyers kind of want to be police officers and police officers kind of want to be lawyers. This constitute word sounds like a legal conclusion to me. And it certainly doesn't point, it's not obvious to me that it points to actual evidence,
I
which is what
understand that.
matters and what our review is based on.
Sure. Well, Your Honor, in terms of the name itself, I would like to respond to your question about the name. I think that it has been held in other cases to be sufficient. I mean, in Curiel, we have the Faith Presbyterian Head Start Daycare. The same issues you raise here would apply to that name in full. I mean, the YMCA is a well-known private organization that deals with education of young people as part of its job.
Counsel, remind me where Curiel came out of.
Curiel, I believe, let me check my brief, Your Honor. I don't want to be wrong.
My main question is whether it's something authoritative for this.
It's
district.
not authoritative. Yeah. I recognize. But Your Honor, I think it's still good. I think it's still good persuasive authority here. Manly doesn't, for all its virtues, Manly does not provide a very firm test on the matter. And so I think that considering what other districts have held is particularly appropriate in lieu of such guidance. We also have in Taylor, which I again recognize is not binding authority but persuasive, we have this Highland Head Start. That doesn't even have the daycare or early learning center. Kindergarten doesn't even have anything, respectfully, Your Honor. I mean, I think that we have enough cases where something that doesn't contain the word school or doesn't make any reference to being a public school is held to be a school just based on the name to meet the statutory definition. And I think that's exactly what we have here with the additional testimony that it is a school which was not objected to, which was not contested, and which was held sufficient by a jury of their peers, Your Honor. So
do you think Manly requires a specific objection as to the identity of the school, both in name or function?
I think it requires, I don't think it requires an objection, Your Honor. I think it stands to clarify what the state's burden is. The state's burden is to present sufficient evidence that this was a school, and it clarifies what is considered sufficient evidence to be presented by the state. The defense never has to object. They never have to present evidence, Your Honor. That's a well-known fact about the defense.
Well, that's the burden of proof, but
Right.
that goes to my next point, which is the description of the establishment as a school. That, I mean, that's a material element of the offense that enhances it from a second-degree felony to a first-degree felony.
Yes, Your Honor.
And so that's a critical thing that was not objected to.
I agree, Your Honor.
And it's, as a matter of fact, there has to be a jury finding on the verdict forms that it did occur within 1,000 feet of a school because it enhances, I think under Apprendi, enhances the level of the offense and the level of punishment as well.
Yes, absolutely, Your Honor. And so my point is, without an objection or without some evidence to the contrary that they could have presented, this is not a school. It doesn't have these particular elements of a school under the statute. I think without that, the defense can't then object and say we haven't met our burden, because Manly and these other cases say we have.
But it's more than just the testimony, it's also the jury instructions and the verdict forms.
Right, Your Honor. So
Okay.
yes, on that point, they would have had to object because you always have to object to jury instructions or verdict forms or forfeit the error.
And counsel, this seems to be compounded because, if I recall, didn't the jury instruction itself not contain the word school?
Yes, Your Honor. I believe that was part of the amended brief, which we were not to talk about today.
Fair, and we don't have to get into that,
But yes, I do agree.
Judge Patton's question, this jury determination as to the facts,
Yes.
we don't necessarily have in this case that they directly landed on that fact. And the lack of objections here compound and confuse the issue.
Yes, it does, Your Honor. On that point, I would just point to harmless error primarily because we have met our burden under Manley and all these other decisions that I've been citing to you for a while now. But if we've met our burden, then it's harmless error, whatever the jury form said, because, I mean, because of the specific nature of the alleged error, right? All that happened in this jury form was they swapped school for the YMCA, right? That's what the issue being raised on that is. If we presented sufficient evidence that the YMCA meets the definition of a school, then that's harmless error, especially in lieu of an objection, plain error. So
Understood, but and my question is regarding the assignments we're looking at today.
yes,
Sufficient of evidence gives a lot of deference to the fact finder.
yes,
And on this record, at least from the appellant's argument, we don't necessarily have that fact finding specifically made. It begs the question, it takes the inference of the argument that school, YMCA, that it constitutes a school, that evidence is enough.
I do understand your point on that, Your Honor. But I still think part of the sufficiency of the evidence test is portraying the evidence in the light most favorable to the prosecution. And so if we're portraying the evidence in the light most favorable to the prosecution, we've proven this is a school, and therefore there is no harm in referring to it as a school in the jury instructions and finding it was committed in the vicinity. So sounds like I'm out of time, but thank you, Your Honor.
Thank you
If
for
there's
your
nothing
argument.
further.
Counsel for appellant, you'll have 5 more minutes for rebuttal.
Thank you, Your Honor. I think it makes sense for me to pick up where I left off in my first argument here. The reason that the cases the state is relying on do not control the outcome here is because the issue that we're talking about, whether a preschool meets the statutory definition, wasn't presented. There's no discussion of that issue in any of those cases. For example, Taylor is the one that I didn't get to just before I ended last time. There, the defendant made a very generic challenge to the manifest weight of the evidence as to both the conviction of the underlying offense and the school zone finding. The defendant was arguing things like the credibility of witnesses, so that's what the court addressed. The statutory definition of a school appears only in a footnote in that case. There was no substantive discussion of what that definition means.
Nor in this case.
But we've raised it on appeal, Your Honor. Again, the trial counsel made a Rule 29 motion and said that there was insufficient evidence to support the school zone finding. That's all in terms of issue preservation that's required in the trial court. Here we have briefed the issue of whether a preschool meets the statutory definition, so it is presented for the court's consideration, unlike in Taylor or Curiale. Again, Curiale, I don't think really on the facts is distinguishable. You all admit that much. But similarly, they weren't raising the same kind of challenges, so the court didn't have occasion to talk about that. If the party didn't brief the issue of whether a preschool or Head Start, whatever you're calling it, is covered, that court wasn't required to sua sponte address that issue. Therefore, we shouldn't imagine Curiale as being controlling as to what the court might have decided if it had that issue before it. In terms of the sufficiency of the evidence, there's the discussion that, yes, it does have to be viewed in the light most favorable to the state, but that isn't the entire test. The question is, viewing the evidence in that light, could a reasonable jury conclude that the state had proven this under their burden of proof beyond a reasonable doubt? Even if we're going to allow, for the sake of argument, that you might infer the possibility, like Judge Lynch brought up, that there could be some sort of public school programming going on at something operated by the YMCA. Still, the most you have is sort of speculation that that's a possibility.
Counsel, on the school point, again, for the testimony of of the officer, how do we differentiate between, I think what you argue is a legal conclusion versus what I think appellee would say, or maybe differently, is that it's a credibility of the officer. An officer knows what a school is. He says it's a school, and I think appellee would say, based on Manley, that's enough.
Your Honor, I think you were on the right track pointing to the use of the word constitutes. I think that does suggest, that specifically suggests that he's, using legal language, trying to say what this is under the law, rather than if there was any testimony suggesting that he had some personal knowledge of the school and can conclude what sort of institution it was based on that, that would make a difference. But there's just nothing from the record to conclude that there's any actual knowledge there, rather than just sort of making a generalization.
So constitutes is what makes it conclusory. If he said, I regularly, see kids there, I understand there's teachers, something like that, might that have been enough from your perspective under Manley?
Potentially. Again, it would have to be something that would allow a jury to infer that this place is a match for one of those three statutory definitions. So if he said he knew maybe that it was a public school, I think that's something that he could be familiar with, as a matter of lay opinion testimony. If he knew what grades were instructed there, that's something he might be able to testify to. I don't know.
Counsel, I don't think Manley got into that level of specificity.
No, I don't. And I think Manley was also relying on the name of the school, the Whittier School, which again, I think there's an important factual difference in this case, which is why I don't think it's ultimately determining the outcome, that Manley didn't sort of split the difference I'm talking about. Okay. Right. Because again, if we could conclude based on the name alone here that this was a school, then again, it wouldn't matter what level of detail the officer got into about his knowledge of this being a school. I guess I should briefly touch on my first assignment of error, since my colleague did talk about it.
You have 5 seconds. So touch on what you will.
Okay, well, the court is reviewing for harmless error. They have to show, beyond a reasonable doubt that this didn't affect the outcome, and relevance is a very low bar. That'd be the best I could say in 5 seconds, Your Honor. Thank you.
Very well. Thank you for your argument. Thank you, gentlemen. The case will be submitted, and we will let you know our decision. And that concludes the hearing on this case today, and we will close the record and welcome again everyone from Berkshire Schools to the hearing of an actual case involving real people. And counsels, we appreciate you both being here and agreeing, I think, to take questions from this audience, which seems a little intimidating, perhaps, maybe more so than from us. I see there's a microphone up front here. Is there anyone who has a question for either one of the attorneys? And after they're done questioning, we may allow you to ask us questions as well.
Not all at once now. I know we're popular.
Yes. Feel free to, why don't you just step forward to the microphone? Some of you guys can kick your buddies and get them up there.
Hi, guys. I have a question. You guys use a lot of body language when you talk. Is that like taught in school?
I think that's debatable. I think maybe some people would criticize me for that and say that it can be distracting from making your point, which if it was, then maybe that's something I should do less next time. I find that sometimes it is helpful in getting a point across. Maybe it's just a matter of habit. I don't think it's anything I was really taught in school. I think it's definitely a matter of personal preference. People do things different ways. That's something you find in practice. As an attorney, you sort of can't help bringing your personality to it a little bit, and people do things different ways for that reason. But I hope that wasn't too distracting to everyone listening from the things that I was trying to say, because if it was, then that would be a negative.
I was taught to avoid it, but I didn't learn that well. In all seriousness, I think it is partially unavoidable. I mean, cases get emotional, and you get emotional about your cases, and I think it's normal and human to express that. So, yeah.
That makes sense. Can I ask one more?
Please.
So I have a question. Do you guys get a lot of cases for EMTs and firefighters?
I guess could you just be a little bit more specific about what you mean?
Well, I'm in the fire EMT program on Auburn, so I was wondering if you guys get cases about like EMTs where they're doing their job but they get sued. Like, how do you argue that?
I haven't personally, no.
Yeah, I mostly deal with criminal work, so I don't deal with a lot of that civil stuff. But the civil side of our office does do some of that work, I know. So, yeah.
Okay, thank you.
Yeah.
I was wondering for the appellant's counsel, I'm sorry, I don't really remember names, but are you the same lawyer for his original trial?
That's a good question. The answer is no. And usually that would be the way you would want to do it. One of the things a defendant could possibly raise on appeal after they've been convicted is that the conviction should be overturned because their trial lawyer was ineffective. And it would be a conflict. It would be considered a conflict of interest for me to go in front of this court and say I was ineffective. So that's normally the way it's going to be, where a different lawyer represents the defendant on appeal after a trial, although it's not always the case. So
Okay.
good question.
I also have one more question for you. I forget what the exact language was, but he was talking about how Forgus could have been in fear for like of being harmed. I was just wondering like why you didn't really go into that much.
So that's also a good question. We have a limited amount of time. There's probably a lot more time that I could have spent talking about this. Something that you have to do is choose things that you're going to focus on. I was pretty narrow in the issue that I basically chose the issue that I thought was the strongest, that I had the best chance of winning, and tried to focus on that as much as possible. The judges have the written briefs that have my arguments on the other issues. So you do have to sort of winnow and choose to focus on a subset of the issues at oral argument.
Okay, thank you.
I was wondering if the reason you get charged more for being in a certain limit of like a school ground is because of potential like harm to students or children there.
That's exactly why.
Okay.
At least I would assume that's why the legislature made it that way. We have to follow what the legislature says, and we can guess it to their intent when we need to. So I would assume so, but I can't say for certain.
So I'm also wondering why it should be classified as a school rather than a place where a bunch of like children or students are gathered.
Well, the problem with that, and even as someone who does think it should be considered a school, is what about a local game store? Is that a school? Is a local dance studio a school? I mean, if we define a school without looking at the statute as a place where groups of kids gather, then suddenly, I don't know, a laser tag arena is a school. And that just doesn't seem right. You know, how would you ever not commit a crime in the vicinity of a school at that point? Does that make sense?
Yes. Thank you.
Yeah, if I may, that's a very perceptive question. And actually in Manley, the Supreme Court case that we referred to here, the Supreme Court talks specifically about the legislature's motivation to protect children. And it talked about protecting schools and children. So that certainly was at least the Supreme Court's view of what the motivation was. Thank you.
Good morning. I have a question regarding the case. I was wondering if attendance of the students attending it was voluntary or mandatory, and if that would like tie into it in a sense, kind of what she asked.
So under the definition, whether there's, that was something that I argued, that the definition of school involves it being for compulsory school-age children, which I think is sort of what you're getting at. Although another problem that we're dealing with here is that wasn't something that was really discussed in detail in the trial, and that can be one of the difficulties in appellate advocacy, is we're limited to basically whatever's in the record, what's in the transcript of the trial. If there's some other information that I think is relevant that I want to bring in that wasn't brought up below, unfortunately, I'm stuck. So sometimes that does create complexities, challenges in arguing appeals.
Okay.
And I will also say, to sort of piggyback off of the last question with this one, the other side of the statutory definition is a school even if students are not there. So if this was committed at 3 in the morning, it doesn't matter that I hope you're not in class at 3 in the morning. As long as it was within the range of that school, it still counts.
Okay, thank you.
Okay, sorry, still more with the school thing. This might be a bad question, but I think we can all agree that schools have teachers and students. I don't know if it makes a difference if the instructors at this learning center have teaching degrees or not. How do you guys kind of qualify that?
That's an interesting question. I don't think that's one that we really discussed in the briefs at all. My reading of the law is that that's not part of the definition. In theory, somebody with a teaching degree could be working at any number of places that wouldn't necessarily be schools under that definition.
Again, it's an interesting question. The difficulty in this particular case is that there really was no testimony about the details of the school or daycare center. Were there teachers there? Was it compulsory? What were their hours? None of that was ever brought to the court. So it really wasn't something that they could argue about to us.
I think it brings up a really good broader point too, which is just about our system of justice, right? So as judges, we have a very, very limited role in what we do. And so some of these questions might be, so if you go to the Federalist Papers, the idea is that we only execute judgment. We don't have will, we don't have power, it's just judgment. So the legislature is another portion of our system. And I think a lot of these questions are good legislature ideas. Very frequently, we'll have cases, or you'll hear about cases on the news, and a judge will make a decision, and the answer becomes, because that's the way the law is, and if you don't like it, you can petition your congressperson to change it, to expand a definition, to limit a definition. There's a lot going on, and for us, it's somewhat, we wear black robes for a reason, and it's because we have to be neutral. And a lot of these questions are something beyond, which is the scope of what we do, but very much a part of our system of justice.
Yeah, that makes a lot of sense. Thank you.
The other thing to keep in mind is that we can only decide cases on the facts that are presented to us. So if you look at a court, what we do is we look at specific facts and make determinations on the right facts that are in front of us, whereas a legislative function, they're making policy across as a general statement. And so when the lawyers are arguing about the name of the school and saying, well, this was sufficient, that was sufficient, they're asking us or not to say whether that's good enough on these specific facts. So on Judge Scott Lynch's point, we are very limited because we're limited to the facts, where the legislature is making policy throughout the entire state.
All right, thank you.
As you all know, we got a little brief on you guys on the Google Classroom, and I was curious, Hickson, what does extraordinary writs mean?
Extraordinary writs are basically filings in an appellate court that originate in that appellate court that are seeking relief that you can't get anywhere else. So for example, one of the writs that I deal with a lot is a writ of procedendo, which is, can the appellate court please tell the trial judge to hurry it up a little? Or there's a writ of prohibition, which is, can the appellate court tell the trial judge to stop? Things along that line.
Thank you very much.
Yeah.
Okay, this is dumb, and I know it's dumb. Why don't you guys wear wigs?
Say again?
The white wigs. Where are the wigs?
I have a ponytail where I try to go down that road, but not all judges
British,
appreciate that. Why we don't wear the wigs? Yes.
Well, I know British judges.
In Canada, the justices there not only wear the white wigs, but they wear bright red robes with white piping, which looks very much like Santa Claus. And I don't know why we couldn't adopt that, but apparently we're not going to.
I'm sorry. The answer is there is no good reason. We pick it. It's picked and selected as a result of custom. Like, so for example, Judge Lynch mentioned that in Canada and England that they wear red robes, but for a period after the death of Queen Victoria, all of the judges wore in mourning of her death black. Well, we just stayed with black. Right. So you're asking for a logical and reasonable basis for what happens, and there really is none.
All right.
Yeah.
I have
So
a second question, if I could ask
Sure.
that. So with this is more directed at you people. Why didn't we just define what a YMCA is and then define what a school is and see how they overlap?
Mainly because, as the judges mentioned, that wasn't done at trial. So we can't
Okay, my
bring
bad.
in new facts for this matter, as helpful as they may have been.
It's a problem that comes up very frequently when I'm working on an appeal, is that certain issues that I want to talk about to the Court of Appeals aren't really spelled out in the record as much as I wish they were. That's why I think
That's what I want.
if anybody does go down the road is interested in being an attorney, I think it's very valuable to be an attorney who does both appellate and trial work. There are many attorneys who don't do trial work. And I think it goes both ways. Having the perspective of working on appeals and seeing, oh man, I wish there was more detail on this one issue, helps you be a better trial lawyer. Because when I go to trial, I understand how I would want the transcript to look on appeal and to make sure I get into those things. And then the other way too, when I'm in the trial court, I guess that's the reverse. The other way too, it helps you, if you're familiar with how trials actually work, if you have experience with that, then when you're on appeal, you can argue from that too, and actually have that rooted in the experience of knowing what happens on the other side. So I think it's very good to be familiar with both sides of it.
All right. Thank you so much.
This question's for Mr. Parker. Did you ever, before they were proven guilty or innocent, did you ever have a client you were defending tell you they were guilty, and did you continue defending them?
Yes, it's happened many times, and it doesn't affect how I do my job. My role is to always represent the defendant the best I can. It really shouldn't matter or make a difference to me whether they're guilty or not guilty.
Thank you.
Howdy, I'm Michael. I just had a question for the lawyers or whatever you call you guys. I'm sorry. But how different is it speaking in front of an audience like this and then speaking in front of the courtroom?
I try not to let it change what I do. Maybe it does a little bit. Maybe you can't help a little bit being conscious that there's an audience and wanting to perform a little. But I try as much to stay focused on the case and just argue it the way I normally would.
Well, I guess now's a good time to do a little pitch for the court. You can come and attend any of the hearings that you want, so there's always the potential for an audience. This one was just a little more guaranteed than we normally have. So I try to keep it the same too, but there's always going to be some element of showmanship that you do when a lot of people are watching.
I appreciate you guys.
This is for the judges. Is it ever
Could you
scary?
speak up? Just speak in the microphone a little bit there.
Is it ever scary to be a judge? If you
It's
find
scary to be the lawyers. But we don't get scared.
Well, what exactly do you mean by scary? I'm trying to understand.
I don't know if there's maybe a gang member or something, and you find him guilty. I don't know if that would
Well, I'm the least scary ever in a room with 10 or 12 sheriff's deputies around, so that's good. There are occasions where judges have been attacked and even shot around the country and in the state of Ohio. So it's something that we're aware of. It's not something that you dwell on every day, but I'll just say that the thanks in part to Judge Lucci, who's sitting in the front row here, who was a former police officer who's encouraged us all to get some training in self-defense and firearms and so forth. So it's something that's on our minds. I will say this. The first case I had that scared me the most was a case involving taking children away from their parents and what we call the termination of parental rights cases. That was scary to me, not on a physical level, but on an emotional level, that I had to decide whether these children would no longer have these parents because of abuse and a number of different things. And that's a heavy weight. So the weight of our decisions sometimes can be scary.
So last year I had 2 high school students and I had them up in my office. We were getting ready for court and I was putting on my robe, and I was a lawyer for 27 years before I had this job. And one of the high school students looked at me and said, "What does it feel like when you put that on, when you put this on?" And the first word that came to mind is sobering, because you have people's lives in your hands. I mean, I'm not trying to be dramatic about it, but I'm sure for Mr. Parker's client, this is the most important thing in his life right now that has to deal with his freedom. And if you think about any one of us, imagine if, God forbid, you or somebody you loved went away for 60 days in jail. Well, what would that do? Would they be able to pay the bills, pay the mortgage? Would your parents stay married if one of them got arrested and disappeared for 60 days? And now we're talking about a lot more time. So Judge Lynch touched upon this when we sat down. I mean, this is a very serious business. So there's a certain moral, I wouldn't say fear, but a moral appreciation for what's going on, even though it's in a legal context.
And I'll add to that too. This came up when we did our courtroom in the classroom a few weeks ago in Portage County, and Judge Lucci, who's here, said something which struck me, and that is it's nowhere in the judicial oath of office that says we have to be right. And that struck me because you ask if it's scary. You are often dealing with life or death issues. And I think in any profession, right? I mean, if you're providing for your family, if you're stepping out every day as a police officer, if you're stepping out every day as a business person, you're taking risks. You don't know what the end result is going to be, but you have to have a certain sense of faith in yourself, perhaps a faith in God, a faith in other people, a faith in your education, a faith in your training, that you're going to do the best you can, and that's all you can do. In our system of justice, it might not be perfect, but it's the closest thing to perfect that we have. So it helps me to face sort of the scarier decisions, if you want to put it that way, is taking a degree of humility and understanding my role in the system and just doing the very best I can every day.
Thank you.
Is the intuition of an officer, a detective, sufficient evidence to convict someone? I believe I remember hearing that a detective or an officer said that it was sufficient to say that the YMCA Children's Learning Center counted as a school. How does that hold up? How does their defining of that?
I'm not giving you the microphone on that one.
Well, all I say is that you will have the opportunity to see our written decision after we as judges conference and come up with that. So I imagine and hope that those will be publicly available, and if it's follow up in your classes, you'll be able to see that and what our court's reasoning may have been, what was on that issue.
I think part of the problem is agreeing on what exactly that comment meant. At the risk of speaking for others, I think if the statement on the record had very clearly been, my legal conclusion is that this constitutes a school, I think we would all agree that that's no good, that wouldn't count really as evidence. But there's some dispute over whether that's really what the officer meant or whether he was saying that he could speak from some personal knowledge or experience that it was in fact a school. So that's another part of the sort of difficulty of the case.
I'm going to take a little slight issue with that. If a detective says this constitutes a rock, everyone knows what a rock is. So that's neither here nor there, but I would qualify that slightly.
The General Assembly wrote a legal definition of a rock.
30 seconds.
This is why we have the two sides.
Don't get us started again. We already used our argument time.
Your time has expired here on that. Thank you for your question.
I do
Go ahead.
one more question,
Sure.
if I may. Mr. Your Honor, Judge S. Lynch and M. Lynch, are you related?
Yes, indeed. Scott is my nephew.
Isn't that?
There are a lot of Lynch lawyers, but yes, we are related.
I grew up in a family. There were 6 lawyers in our family. They had when my father died, he had over 65 grandchildren, and a bunch of them are lawyers as well.
All right. So correct me if I'm wrong, but I was looking around. Mr. Forgas is not present today, right? So I guess I was just kind of wondering what kind of the policy usually is on, whether that's required, whether it's kind of not allowed for the appellant to be present.
All right. So keep in mind that we hear both civil and criminal cases. This clearly is a criminal case. Mr. Forgas is incarcerated, I know not where, but so he's not going to be present for this. And even in civil, even in cases where the defendant might be out on bail or some such thing, he's not actually in jail, they're not required to show up. And there's no evidence presented. Remember, we're not here to listen to someone re-arguing an issue that was never presented to the court below. We're only here to go over what's already been presented. And so there's no opportunity for Mr. Farkas or any party in a case, even in a civil case, to come in and give us new evidence. So typically, we actually don't see the parties. Occasionally, particularly civil cases, you'll see the parties will sit in the audience. And as was talked about earlier, if you come out to our courthouse in Trumbull County, where there's probably enough seats for 40 or 50 people, you'll come in on any given day, and there's usually not more than 2 or 3, and they're probably the lawyers. So the parties don't typically show up.
So you argumented that there was a point in time where Ferguson was safe from the threat potentially. If you were in his shoes, what would have you done to not end up in the spot he's in right now?
Oh boy. I mean, there are a lot of very different choices I probably would have made leading up to this point. But I mean, the problem with the duress defense is because it's putting innocent people at risk, right? Somebody else got hurt because you wanted to save yourself. And that is valid. There are points where that's valid, but that's the reason that it is so narrow. I'm going to refer to what this court found in Strickland, where somebody was allegedly held at gunpoint outside of a gas station and told to rob it. And what the court said in that case was, as soon as you walked into that gas station, why didn't you ask the clerk to call the police? Why didn't you hide? Why didn't you do any number of things to avoid being in danger and also avoid hurting someone else? So does that make sense? In this case, he could have walked away. He could have driven away. He could have done anything to avoid being in that situation from my point of view. Does that make sense?
Yes. I also feel like he could have been scared that the other person wouldn't have been convicted of anything. It would have still been out there. Like, there's always that chance, and something could have happened to his sister-in-law, if I'm not mistaken.
I totally understand that but that becomes a legislative issue then, right? Because that's not how the duress defense is currently understood, and we can't argue we need to redefine duress. We need to make this defense something that it's not currently. Because that's just not our job. Does that make sense?
Yes, thank you. You said that you weren't the original lawyer for this case. So how would you prepare for something like this if you weren't the original lawyer?
So when the trial is happening, there's a court reporter in the room who creates a transcript. So I get that. I get to read all of the testimony, everything that was said on the record in the trial. I also get to see whatever exhibits were presented to the jury because those are preserved for review. So I review that, and that's how I prepare. Does that answer your question?
Yes, thank you. I was just wondering, have you ever been a defender for a case that you didn't agree with personally, and like, how do you keep neutral for that?
Sure. I think, so first, yes. And that's part of the job. Especially doing criminal defense, often I'm representing people who are accused of things that are, that are unsavory, that of course I wouldn't agree with. I guess my personal philosophy is I believe that in the big picture, justice is always best served by me doing the best job that I can for each one of my clients, because that's necessary in order for us to have a fair justice system where everybody's treated fairly. That's how I view it.
I took a debate class at my old school and we had to learn this skill, and I was wondering why this skill wasn't enacted here. So I'm just wondering, why don't you guys have like a personal device to fact check the other, like to see if their sources are correct or something like that?
Well, that does happen in the written briefs. I write my brief and I cite to certain legal authorities, and he cites to certain legal authorities. And I think part of what we were doing was sort of debating the correct interpretation of those cases. I think it may be one thing if somebody had sort of misrepresented what a case said. I definitely don't see that happening here. But these things can often sort of be complicated, and I think two reasonable people can disagree about what the correct interpretation of a legal matter is, and that's a lot more what it comes down to than fact checking or saying that something's incorrect. Is that sort of what you're asking?
Yeah.
Okay.
Thank you so much.
I would just build on that a little bit in that very rarely are legal decisions cut and set in stone in regards to the specific thing you're arguing. If the Supreme Court said the sky is blue, that would be one thing, but we don't have, like, in this specific circumstance, under these specific facts, here's how it is. So it's hard to say for certain that, like, that's wrong, like, firmly. Does that make sense?
Yeah. Thank you so much.
Hello, everybody. My question was to everyone was, with Forgus's case, when he was charged with the holding drugs and stuff, why wouldn't he not be indicted? Because he was forced to hold the drugs and sell them because he was almost, I know you said allegedly, I don't know who the guy was that was giving Forgus the drugs, but he had a gun held to his head and told that him and his sister-in-law or sister would be hurt or killed in that way. And I know, he still did the crime, but why would it be a tier 1 instead of a tier 2 level of case?
Well, I'll start with that, in that you don't have to accept everything that's said as true.
Yeah.
We do not accept everything that is said as true, and I personally, and in my brief, disagree with the portrayal of the facts by Mr. Forgus.
Yeah.
So if this was a case where on video someone has someone right behind them with a gun to their head, walking them through everything, then that would be a very different story.
Yeah.
But because we don't have, as that very firm proof that that's what happened. Does that make sense?
Yeah.
You want to talk about that at all?
No, I think that's a good answer.
Okay, thank you.
My question is specifically about officer testimony. Obviously, in this case, the defense focuses on the testimony of the officer. So my question is, how does officer discretion affect your trial, and how does it affect their testimony, as officers have the right to use discretion in cases?
I'm sorry, could you repeat just the last question?
The
last part of the question?
How does the officer's right to use discretion affect their testimony in court, and how does it affect your defense and prosecution?
Sure. So we have a lot of cases that deal particularly with like suppression of evidence or things like that, where the officers do have discretion for things, but it has to have a basis, right? And that's sort of the issue that we've been arguing a little bit about with the school is, yes, they said this thing, but do they have a basis for that conclusion? And so there is discretion, and you listen to an officer like you listen to anybody else, but there still usually has to be some basis for that at the end of the day. Does that make sense?
Yes. Would you say that an officer's use of discretion could be beneficial? Because, like, especially in cases like getting pulled over or anything, an officer can use discretion for being able to be like, hey, I really want to see if you are like a drunk driver. And they can then use their discretion to make that citizen then do the tests and everything. Would you say that's beneficial?
Boy. Don't get me started on the suppression of drunk driving tests. Yes, that is a big part of our job as prosecutors, is building cases based off of that. But it's a big part of the defense's job in those cases to argue that the police had no right to do that. So it can be helpful. It can also sometimes be a little dangerous because there always has to be that basis.
I just wanted to see if the defense had anything to say about it.
Sure, I think that's a pretty good answer. And yeah, that's part of my job too, is to challenge, was this within the officer's discretion? Did they have a good reason to do this to begin with? That discretion is limited, and it's often my job to sort of enforce where the limits are. As it affects this case, an officer could have discretion to do certain investigative acts, but their testimony doesn't get any particular deference. We still just have to assess that as you do any other witness.
Okay, thank you.
And I think your question too is helpful to think about our larger system of justice, where there are so many people involved. There are so many layers of decision after decision after decision that people have to make doing their own job and exercising their own discretion. Prosecutors have discretion whether to bring charges in the first place, right? So there's just so many layers and so many individuals involved. It's really an amazing thing to think about, the moment of an appeal that happens. And I think an earlier question was how appellant's counsel prepares. There's a record. There's so many things that go on, and this moment that we're arguing about is a collision of almost infinite facts and decisions that people have made, and it's also colliding with an entire legislative and judicial history of how we look at all these different cases and perspectives. So it's a unique thing. It's always interesting, and it's there's a joke that if you ask a lawyer everything, he always has one answer, and the answer is it depends, right? So we really get to look at the details of every case, and there's so much that leads up to it, and it's just an amazing system we have. I know when we as judges in general, the five of us, and Judge Lucci in particular, brought the courtroom in the classroom idea to us. It had been done in the past, but what we're trying to do is commemorate the 250th anniversary of the founding of our nation on July 4th, 1776. And I'm the newest judge on the panel, on the court. I've been here for just a little over a year now. I started in February of last year, and it's a really humbling experience to sit here from this perspective just all the things that have had to come together for every single case for justice to be served. And hopefully you all are getting a glimpse of that in a different way today.
Thank you so much.
This question is for Adam Parker. What made you go from a music major to an attorney, and how?
Tough question. I wanted to be a musician for a long time. I honestly, at a certain point, had a realistic conversation with myself that I didn't think it was going to happen, and also had a lot of tendonitis and couldn't really play seriously anymore. And it took me a little while, but I figured out I wanted to make the career transition. Honestly, I took a bit of a gamble. I didn't know if I was gonna like this, but I think it's worked out well for me. I do really like being a lawyer.
What instrument?
Piano.
This is for the appellee and the defendant, or appellant, sorry. Sorry.
We
stutter.
mix that up sometimes too, don't worry.
Earlier, you got a question that said that even if the person you're defending admits that they're guilty, that you have to still defend them in court. If you think that it's generally like really morally wrong what they did, can you refuse to defend them?
You could. I believe the rules of professional conduct do give an attorney that option. My personal philosophy, and I think most people who choose to go into the field of criminal defense would share this philosophy, is that you wouldn't do that, that it is still your obligation to represent the defendant as best as you can, and your personal feelings about the matter shouldn't enter into it too much.
Okay, thank you.
How much do you guys make monthly and yearly?
Objection, I think.
Yeah.
It might be the right response to that.
I don't know. I don't keep good records. Sorry.
We won't put the lawyers on the spot.
We're public service.
Yes.
So that's a no?
That's a no.
All right, thank you.
Hi, I was wondering why you get 20 minutes here and 15 minutes at home, because I remember you mentioned
It was strictly at our discretion. As you can see, we're fairly liberal in the timing. When we've had cases, even though we say it's 15 minutes, we've had cases where we had a number of questions from the judges today. Sometimes you have a lot of questions from the judges, and the 15 minutes isn't sufficient, and it'll bleed over into 20, even 30 minutes. But it's pretty much at our discretion. And we do that in part because we understand that this is a different setting for the attorneys, and we want to make sure they're able to get their arguments to us completely, but also to you, because you have a summary of this case, but we have a lot more. We have all the briefs, all the exhibits. There's even a video involved in this case. And so all of that is available to us. So we're much more aware of all the facts and circumstances, and we want to make sure you understand it as well. So we give them a little extra time.
So does it not affect the case at all if you have more time than you?
I don't think it affects us particularly.
It's helpful to have more time, I think, especially in this case. There were some complicated issues to dig into. So sure, I think it helps, if anything.
If we gave them 30 minutes, they'd take 30 minutes. If we gave them an hour, they'd probably take an hour. So
Okay, that's all. Thank you.
thank you.
Hi, my question's for both the judges and the attorneys. I was just wondering what kind of schooling you guys did to get in these positions, and what you would tell students like us that might want to pursue the justice system, like how we make good judgments of we'd want to pursue this, and just kind of your recommendation.
Sure. So it's 4-year undergraduate, and then law school is 3 years. I think there might be some sort of alternative programs where you can do it longer, but that's pretty much the normal way it goes. To people who are considering law school, I know some people find it maybe a little bit intimidating and question whether they're up for it. So I would encourage people, if it's something that you want to do, don't be intimidated. It's very doable. If that's something you're interested in, it's something you're capable of, and you shouldn't be scared off.
Yeah, I would also just add to that, practice your reading and writing now. That's a huge skill that law schools look for, and it is increasingly a differentiating thing. So the better you're writing now, the better you're going to write in law school, and that's very helpful. So.
Yeah, I would generally too, it sort of sounds like cliche advice, so I'll add something to it. But I would say pursue your passions in a measured way, right? There was a question earlier about a music school background, right? Everybody brings their sort of unique interests and their unique background to the job that they do. And if you have really had the skill at committing yourself to something and just being great at it, you know, I don't care if it's a sport, if it's an academic interest, when you learn that skill, that you've aimed for something really difficult and you've put in everything that you had, that you push yourself past those limits, that you've surprised yourself, you've surprised your family, and gone through all of those struggles to do it, that's going to translate to a legal career in some ways better than anything else. Now, you know, do the practical things, you know it's involved. Rhetoric is, kind of an old-fashioned topic, but for me, getting into psychology and what really drives people's engagement, what really drives people's decision-making, the question about being sort of emotive, using gestures. We are three regular people. We're lawyers and we wear black robes, but the skill of really understanding human behavior, what drives people's attention, what drives people's needs, what drives them to make decisions. If you can become skillful at that, forget about just the law. You can do anything. In my opinion, that the top performers in the world are people who really understand that human psychology, that human interaction. And you can't replace life experience. You can't replace just try to be excellent in something, and you're gonna get a lot of those lessons along the way. And one day none of us are perfect. We're all aiming towards the next thing. But you'll do things that might even surprise yourself. And to me, that is sort of the secret sauce of becoming a great attorney or whatever it is that you want to do, is applying yourself, going through those difficult challenges.
With the stereotype of kind of law school and being a lawyer of drowning in work, would you say that this career is more consumes your life, more than just a regular job would?
My office specifically is set up to try to avoid that. I know that it's a lot of work, and I'm not going to downplay that, but you have to have some sort of balance between your work and life, or it's just not going to work.
Okay.
It also depends on where you work. So if you're at Jones Day, which is some people refer to Jones Day nights and weekends, they have you'll get out of law school and you'll make $200,000 a year, but you'll be billing out a minimum of 2,200 billable hours a year, and you won't go home. You'll go home, but you'll have very long days. Your days will start at 7 a.m. You work till 7 at night. And in some instances, you'll be expected to work overnight to get things turned. And they have cots there, so people who sleep, they can go back to work. So it really depends on where you work.
Thank you.
Hello, I had a question on what drew you guys or interested you the most about prosecution and defense, and if the education or what you learned about differed between either prosecution or defense.
Well, I think the law school education that we got would be more or less the same. I did do a legal clinic while I was in law school that was specifically about criminal defense, but you take all the same classes. The course of study is basically the same. This was always sort of the side that I was drawn to. I guess I sort of liked the idea of sticking up for people who were in very difficult situations. Mm-hmm. And I liked the sort of being in a role where I'm sort of a check on the legal system and the position of sort of protecting legal rights and making sure that those are respected throughout the system. I guess that's a big part of what drew me to the defense side.
100%.
Yeah, so my draw to the prosecution is that in a way, I think prosecutors are as much of a check on the legal system, if not more than the defense. I'm sure the judges sometimes get a little annoyed with me because if we did something wrong, I will explain at length how we did something wrong. And so the prosecutor's job is unique because we have a specific section of the rules of professional conduct that says our job is to see justice done. It is not to obtain a conviction. It is to make sure that whatever the right outcome for a case is the outcome that we push for. And I take that very seriously.
Thank you. Thank you, guys.
Like, what would you guys say is like the hardest part about your job, like currently?
Well, that's a hard question. I think there's a serious responsibility. You know, I try as much as possible not to lose sight of the fact of how the work I'm doing affects my clients' lives. Sometimes that gets to be a lot on my shoulders. I strive to do the best that I can. You know, I know that I'm not perfect and that there are sometimes going to be mistakes, and that can be a difficult thing to cope with when you know what the stakes are. That's probably the most difficult thing for me.
I'd say especially recently, there's a sort of strangeness that I've encountered a lot that is more odd than uncomfortable, in that, like, sometimes the easiest appeal you'll ever handle is for a murder trial. And sometimes the hardest appeal you've ever worked on in your life is a misdemeanor that no one's even going to jail for. And sometimes that's odd because it feels like, you know, here I am spending 2 weeks of like nose to the grindstone work on making sure that someone pays this guy $200. And sometimes you're like, okay, well, I knocked this out in a couple of days and this person is facing life in prison. Like there is something in that like is uncomfortable in a way. Does that make sense?
Yeah. Thank you.
This is for the judges. Have you ever illegally been offered a bribe?
I think I can speak for all of us and say no. That's never happened.
All right, thank you.
Only in the movies.
If I did, I'd call the FBI.
Yeah, that's right.
And I'm going to get on my, America 250th shtick too, like the culture of our legal system. If you go to certain other countries, bribes happen. In fact, I vaguely remember an international law course that I took during law school. And in international law, they differentiate between two different types of bribes. One bribe is to bribe an official for a duty that they are not allowed to do. And another bribe is for an official to perform a duty that happens to be a part of their job anyway, and they are allowed to do. And at least at that time, that second type of bribe was generally considered okay by some in the international community. I mean, I'm not going to get on my high horse too much, but like our system doesn't work if we're not moral and religious people. So the reason that our justice system works so well is because all of us have an everyday sense of right and wrong, that a question like that, have you ever been offered a bribe, is sort of funny and out of the question. But that's not true everywhere. And I think it takes a moment of reflection about the goodness of our American system, that is still generally the culture that we have. Now, other people will criticize, there's lots of other legislative issues that things are legal that maybe people say should not be legal. But when it comes down to our justice system, we have a really, really clear sense of integrity beyond anything else, which to me is uniquely American.
What is jury duty?
Well, we never have it here, that's for sure. So the appellate court, we never have juries, but the jury duty means you've been called theoretically at random to come and sit in judgment. Much of these questions had to do with the various facts of the case and how they might be weighed and what is the school and so forth. Ultimately, the jurors have to take all that information and make the decision in the case of guilt or innocence. So it's something that people try to get out of, and you should all look forward to it.
How and when did you guys know you wanted to become lawyers?
It was not something that I wanted to do all my life. It happened when I was a young adult. Not very long before I decided to go to law school, honestly. I made the decision. Like I think I said in response to an earlier question, I did take a chance on it. I wasn't sure if it was going to be for me, but now that I've been practicing for 7 years, I do like it a lot.
I always wanted to be a lawyer. Since I was a kid, I just thought it was fascinating. And my family had occasion to have a very good lawyer for a case that was very dear to us. And I wanted to be that lawyer for somebody someday. Though I will say, before that experience, my parents used to joke that the most rebellious thing I could be in this world would be a lawyer. So,
Thank you.
Out of curiosity, does religion or like a belief system ever like affect the way that you guys do your work?
Was it religion, or what was the other thing?
Like a belief system?
A belief system?
Like,
Well, as you heard in this case today, it really doesn't become an issue.
yeah.
The facts are the facts, and the law is the law. So we never know anything about the defendants, typically what their belief system might be, or what their religious behaviors might be.
Yeah. Is there any like personal beliefs or anything that might affect the way that you guys trial or decide things?
I mean, I talked about it a little earlier, but part of the prosecutor's duty is ensuring justice is done. And sometimes my personal beliefs have to affect that, because what is justice? Unfortunately, I can't get a Supreme Court case to tell me what the definition of justice is in any particular case. So sometimes it is going to be, there are value judgments about what justice is and what is being done right or wrong in a case. But at the end of the day, you have to follow the law and make a good faith argument, and you can't let your religion, belief system, or personal feelings play into that one way or the other.
Yeah, I think the answer is, when you're doing your job as a judge, definitionally the answer is no. But from a bigger picture, I would argue a part of human nature, it's what drives all of us. If you take any decision that you're making, something you're doing in your life, that you want to pursue this or you want to pursue that, and you really try and drive down deep, you keep asking the question, why? Well, I want to go to school. Why? Well, I want to get a good job. Why? But if you keep digging down that why, you're going to arrive at some really basic values of what drives you as a human being. For many people, that's going to be a religious question. For many people who don't have that ultimate why as a religious question, some people might say, well, it doesn't really make a difference because it's kind of like a religious question, because I want to do this too, because I want to be a good man, because I want to be a good person, you know. So grapple with those issues as students, you know, getting a sense of what really actually motivates you, not the sort of fluff that we might tell ourselves in the morning, or just worrying about, you know, the test we have to take that day. But if you really drive down on what actually motivates you, it's going to make you much more capable to do your job.
Thank you.
This is a question for anyone. Have you ever felt guilt or like second guessed yourself by a decision you've made or a person you've been defending?
Could you repeat that again a little louder?
For a person you were defending, at the end of the day, have you ever felt guilty or like second guessed yourself by a decision you made or a person you were defending? Like, have you ever felt bad or like a...
No, that's not a decision that I feel bad about. Again, I do think it's my role as a defense lawyer. And this is something sort of in contrast to what Dane was talking about. His job is not to seek conviction, but to ensure that justice is done. My role as the defense lawyer actually is different. I'm supposed to stand up for my client no matter what. My personal feelings aren't supposed to come into it. Of course, there's rules of ethical responsibility that I have to follow, but within those bounds, I'm supposed to do everything I can to my client's benefit. And how I personally feel about it shouldn't matter. If anything, when I feel bad is when I look back on a case and feel like there's something that I should have done better or should have done differently.
Thank you.
I will say it does happen sometimes. There are cases where so occasionally, and I won't say which ones, I come in expecting to lose and then I win. And that is hard sometimes, because sometimes you look over what happened and you wonder if you did the right thing. And that's just human. But the law is the law. And if it's followed, then it was done right.
Thank you.
So my question is specifically for Mr. Hickson. So in the initial part of your argument, you talked a lot about duress, and you said that one of the points of it was it cannot be applied if there is not imminent danger or imminent harm to the person bodily, or I forget the exact definition. But it seemed that there was a somewhat limited use of that through the fact that you kind of only talked about the fact that imminent was used as time, as in they're not exactly there time-wise, when imminent can also be applied to there is a guarantee of it happening at some point. So if something's imminent, it doesn't have to be there presently, but you can know that it will happen, which also makes it imminent in that sense.
That is a great point. That is why I mentioned that the danger must be in presente, which is a Latin term that we use in regards to the duress defense, which means happening in the present moment. So imminent is the word that a lot of these cases use. I agree that it can be a bit imprecise at times, but in presente is the term that I prefer because it does get across that it has to be happening right now. Like I mentioned in the Strickland case, even if you just go inside out of range of the guy with a gun, it ceases to be that imminent in presente harm.
Gotcha. Thank you.
Okay, shoot. Why is it that lawyers seem to have all sorts of weird college majors in a way?
I'll give you the joke before I hand it over to my colleague for a serious answer. There was a joke among some of my colleagues in earth and environmental sciences, which does not have the greatest job market, that if you can't get hired there, you should probably go to law school to make sure you can meet. So that's the joke answer.
You're sticking with me with giving the serious answer, huh, Dan? I guess the best serious answer I could give would be maybe relating this back to what Judge Scott Lynch said earlier about essentially any background can lead you to a successful career in law. There isn't necessarily any one correct path. Other than that, I'd have to take responsibility for my own personal idiosyncrasies and weird majors.
I'd also like to ask the judges, do you guys think you have a decision on who you think is going to win this case? I don't know if you can answer that here.
Yeah, the process is that after we adjourn, we'll have a meeting between just the judges, what we call a conference, and we'll discuss all that was talked about today, and indeed things that weren't even talked about today, and arrive at a consensus. There's 3 judges, obviously. So we have to have 2 of the judges agree on the decision, and you could have a 3rd judge who dissents. You could have a 3rd judge that kind of agrees, which we call a concurrence. So he agrees with the bottom line, but he has different reasoning involved. So, we're not prepared to announce our decision today, but we will ultimately announce it in writing with a written opinion about how we arrived at the decision. So you can all look forward to reading that perhaps in school. Thank you.
Hello. Am I loud enough?
Yes, speak up, but go ahead.
I'm concerned I may have missed this section, but I know you mentioned a school is a school if it's K through 12. Like a preschool and a daycare isn't. So what would a preschool and a daycare be, if not like a school to teach you how to do school?
Right. I mean, I think the difficulty there is that it is a school in the common sense usage of the word. However, the statutes that create this sentencing enhancement for offenses that happen within a school, that includes a specific definition that say, okay, in this statute, the word school means this. And that's something that commonly happens in law, is that there's legal definitions for words that we might be familiar with in an everyday sense. But when there is a legally defined usage of that word, that's what matters and not the everyday usage of the word.
One more thing. Could we get a picture with you guys when we're all done?
Fine with me. Can we do that? Yeah, sure.
We can get a picture, I presume. Judge Lucci's giving me the nod, so I guess that's okay. Thank you.
If you're able to disclose it, what were factors that are able to be talked about behind closed doors? Oh, what are factors that weren't talked about here, but you are going to talk about behind closed doors?
Well, that'd be a long list, actually, because as was talked about, there's a transcript which is several hundred pages long with all the testimony in it. There's video. I mean, there's all kinds of evidence that was not gone into in any detail, all of which is available to us to review in order to try to reach a decision. So,
And 2 assignments of error.
yes. And in this case, particularly, as Judge Esselinch reminds me, is that you only heard 3 of the 5 arguments that are actually involved in this case. There are 2 others that were not debated today, so quite a bit. All right, and I see that the line is empty, so thank you all very much. It's been fun for us to be here. We hope you've learned something, and we'll look forward to seeing you again.